And this presentation is going to be a great one as well. It was accredited by the LSO for 1 hour of professionalism content. So make sure you stick around for this one.
Yeah, certainly a dream team that you've assembled for this one. Golan, Steph, Abiola Adeusi, who's fantastic. It's going to be a great discussion.
Okay, so today we are going to watch the session, Ethics and Strategy in the Legal Profession. And we are joined by Abiola Adeusi. Abby is the founder of Abiola Adeusi Professional Corporation. She completed her law degree in England in 1993, later trained as a solicitor after taking a break to have her family, and was called to the bar in Ontario in 2010 after relocating to Canada with her family in 2008. Abby is a trained collaborative lawyer and a trained mediator. She is dedicated to her clients and uses her vast knowledge, critical thinking, and problem-solving skills to assist her clients. Abby believes in giving back to the community and is the past president of the Peterborough Law Association. And she's passionate about her clients, and what matters to them matters to her. So thank you so much, Abby, for joining us today. Looking forward to the presentation. And we are also joined by 2 lawyers that work with Russ at his firm, Stephanie and Golan. Welcome. So happy to see you guys. We'll start off with Steph. Stephanie has been immersed in family law for over 6 years. Over the course of her legal career, she's gained experience managing a diverse caseload, including highly sensitive matters, negotiating practical solutions tailored to her clients' goals, and advocating for both inside and outside of the courtroom. Stephanie was called to the Bar of Ontario in 2022 and recently had a successful result from an ex parte motion published on Canly. What drives Stephanie's passion is the positive difference she can make assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. So thanks for joining us, Stephanie. And we also have Golan. Golan Yaron is an associate family lawyer and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiation agreements, as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of court, including on appeals. Thanks, Golan, for joining us again. And we also have Russell. And if you don't know who Russell is by now, you can find his bio on our website. And hopefully
Stop. I don't want any more. Stop.
How many times have you had said Russ's bio today?
Just got it memorized.
100%.
Yeah, I probably do. Okay, so without further ado, I'll pass it over to the pros to get started with the presentation.
Let's run our first poll and get our audience feedback. I love hearing from our audience. They've been participating and playing full today. Thank you so much. Also, thank you for sending in your questions. I think one of our presentations, we had 39 questions come in, which is just great. So really appreciate everybody playing full and participating today. It makes it a lot easier for us to understand where your head's at, how we can tailor our material to meet your needs. First question is, how often have you been asked to represent both sides of an agreement in a family matter? This is kind of an interesting question, but Abby, back in the day, right, 30 years ago, this was not uncommon.
Absolutely. And I think sometimes it depends on where you are.
Right.
If the community is not as much, not that many lawyers practicing, you find that happen quite a lot more than nowadays, of course.
But common sense would dictate. Our clients tell us, we've agreed on everything. Why do we need 2 lawyers, right? Just put it together for us. And it was commonplace back then. That was my experience. How about you, Golan?
Yeah, actually, just recently I had a guy that told me exactly these words. we already agreed on everything. Why do we need to take two different lawyers? And you have to go through the whole concept of why. And I'm sure that we're going to touch on the issues of conflict right away. But yeah, it's still happening. I think some of it is maybe lack of education or the perception of why are we making it more expensive than it should be. So that's one of the driving motivation for clients to try and do things together, the same way that we have a joint application for divorce in a sense, which is also kind of they figured if we have that, why can we not have a joint separation agreement? But that's
the famous simple divorce. I still haven't come across one, but I know they're out there somewhere. Now, Steph, you represent the sort of the next generation of legal talent. I'm sure you've never represented both sides.
Never, but surprisingly have been asked that. I actually remember back when we were, in the office all the time and I was, working at the front desk, early in my sort of legal journey. We had two parties come in and it was separating spouses asking if they could just have the agreement drawn up and, having to go through that conversation about this. That's just not possible.
They probably wanted it done on the spot too, right?
Yeah,
like that
quick
day.
and fast.
We should just put a drive-through window in our office and we'll hand them the paperwork and then
what I tend to say to them is that which sometimes quietens the voice is that you have, as a lawyer, one has a duty of loyalty to one of them. So so when you kind of explain that, how can I almost speak from both sides of my mouth and be loyal to you and be loyal to you, especially given that you're separating, right? It's a much more difficult place to be. And then sometimes the light bulb just like, oh yeah, okay, yeah, that makes sense.
When somebody comes in to set aside an agreement, that's one of the first thing lawyers look for, right? Did both sides sign off? How was this thing executed? Duress, red flags. But let's see what our audience thinks. Never 25%, rarely 41%, regularly 19%, very frequently 15%. So that's interesting. I'm wondering if the regularly and frequently would be from smaller communities or more seasoned counsel. But Abby, conflicts of interest, what do we want to be considering when dealing with these issues?
Conflict of interest. So like I said, the first thing that comes to my mind is kind of the duty to be loyal to one person. So you can't be loyal to one person. You can't be loyal to two people who have potential adverse positions. I'm going to assume that all of us and everybody participating knows that the first thing you do is you do your conflict check. So I'm not going to talk about that because that seems to be like a no-brainer for us. But once you've done your conflict check in your system and you've made sure that you haven't spoken to the other party, it's kind of my position and practice to constantly be aware of the potential for conflict to come into play as the matter progresses. So we have to be constantly aware of that because we do have to avoid conflict of interest at all costs. And yes, it may be what our clients want to say, oh, act for me, act for the both of us on this issue. We have to remember that we have a duty, professional duty, to not only act and be loyal to one person, we also have a duty of confidentiality. So when you're acting for both parties, you can't be, how do you keep one thing? You'll be keeping one thing away from the other. So it's important to ensure that we always make sure that we are checking through and making sure that we are aware of conflict and a potential conflict. Sometimes I've had in a matter where I've been asked to represent, someone that I know, and that created for me that I would be in a position of conflict, not only because I know the two parties, and it's just difficult to kind of step into that fray. So I do send them away. But if you find yourself in a position where it's something, you find yourself in that position where you're in a potential conflict of interest situation, you have to speak to both parties. Either step away. First of all, you have to disclose it to both parties. That's number one. Number two is, if you are going to continue to act for one or the other of them, you must get informed consent, and you must get that consent in writing, and make it clear. Your consent must be very clear, very detailed, and have both of them sign it. It must be in writing. Sorry, Russell.
No, I was just going to add, knowing the person is difficult, right? If you're practicing in a small community, usually lawyers are fairly prominent. You know everybody in that community. You almost need to live somewhere different than you practice.
And just because I was thinking about this earlier on, it's even if one of them gives you consent to act, I would suggest that we continuously go back to that to make sure it's still okay. Because what tends to happen, and I've seen this happen, is when things don't go the way the other party wants it to go, suddenly, that conflict or that appearance of conflict comes into play. They tend to forget that they had signed that consent, granting you permission to act for, party A. So it's always, even with the consent in writing, it's still always a dubious area to step into, especially in family law. So for me, in my practice and personally, I would avoid it at all costs, because it really isn't worth it. And some people might say, well, whatever, because it's that ongoing duty if you find yourself in that position, and it's very easy for things to shift. And you will, yes, you have your consent. If there's a complaint, you have to then deal with it. And, do you want to open yourself up to that? And, that's kind of a decision that the lawyer has to take.
Even the way you deliver the information that there's a conflict. So oftentimes we'll have one spouse meet with one of our associates. A few days later, the other spouse comes in and we've already been retained. But we got to be very careful on how much information we disclose, because we still have that duty of confidentiality. So it's another thing you want to be mindful of. There's also the perception, right? When we do in-court hearings, oftentimes I'm friends with the other counsel. I know their children and their wife, and we'll banter a bit and maybe joke around, and the clients get quite upset about that. They're saying, why are you cozying up to that person? Are you not advocating for me? And so you've got to be really careful in terms of how clients are perceiving your representation too. Golan, do you want to jump in on this at all?
I was actually thinking of that, the last comment you made. It's really about understanding that professionalism has nothing to do with the personal relationship with the other counsel. It doesn't mean that you cannot be zealous with your advocacy when the time comes, but in fact, I believe that it makes a better advocate when you're able to have a good relationship with the other side, whether it's going back to the negotiating table or working arrangements for the client. In essence, it actually a better constellation when you are friendly with the other side. But yeah, obviously, from client's perspective, when they see you with the enemy type thing, then it doesn't the optics of it doesn't look good to them, and it's not the but I think that it goes with some explanation to the client to understand the adversarial system, and the fact that we are all members of the same association. We're still colleagues, we're still human beings, we still have a relationship outside of the work, and it doesn't mean that you selling your client just because you know the other side. And the other thing that we're thinking, what Abby was mentioning about familiarity with clients that may come in, maybe because they're friends in the community, maybe you go to church together. One of the things that I tends to do when it happens is just offer myself as a mediator, and that's the only extent that I will. So rather than just sending them away, it will say, because you both trust me as your friend, if you take me as a mediator, I'll be able to help. And then at the end of the day, you still have to be encouraged to get your own independent legal advice to, with respect to any drafting of an agreement that we may come up with. But the idea is that you rather than sending them away and showing them that I don't want to help you, even though you are my friends, I can still help you, but nevertheless, you're going to have your independent legal advice, because that's what the law requires, and you need to be aware of your own. You have to make your own informed decision, one way or another, even if you decide to decline it later on. That's my comments on this one.
That's an interesting take. Help them structure the settlement, but don't sign off on it. Go see your own lawyers. Steph, any thoughts on this?
Yeah, I would just add to that comment you made of a perception of bias. I find in family law, if, say you're assisting a client and their new partner is actively involved in the file, what happens down the line if those two parties get together and then again, you have a returning client. So just being mindful of any apprehension or any perception of bias in the future as well.
Yeah, good point. So let's go back to our audience. Poll number 2, ethics and strategy. How often have you signed off on an agreement that you believe to be unfair in a family law case? I remember the late, great Phil Epstein at one conference said he wouldn't want his name attached to anything that's unfair. He just wouldn't do it. But I know some of the lawyers will charge a premium. They'll say, okay, well, you're going to cover off my LawPro deductible and charge a $10,000 premium and sign off. They're of the view clients are entitled to make bad agreements. Who are we to stand in their way? We tell them what the consequences are. We give them the advice, and they want to sign off on it. They're independent adults. Let them go ahead and do it. So those are sort of the bookmarks that I see of this discussion. But let's go to our poll results and see what our audience thinks. Never, 46%. Rarely, 48%. Almost straight down the middle. Regularly, 6%. So it's interesting. The regularly one, I guess that's the group of professionals that want to respect the client's autonomy and they can make their own decisions. So thank you for participating. That ties us in nicely to the next subject matter, signing off on unfair agreements. Golan, we've thrown you a lob ball. Let's see.
No, it actually, and I was trying to reflect on it because, the poll suggests rarely, never, and whatever. I think I fall into the category of it happened to me once in my career in 25 years.
In
but
when you're in high school or what?
No, the thing is, there is a degree of unfairness of agreements, right? I mean, unfair agreement could be anywhere from giving away the farm to something that, okay, I'm giving you a little more in the equalization, just to to end things nicely and amicably, or maybe you're not entitled to that extra bit of payments, but I'm still giving it to you because I'm a good person, whatever the reason may be. The first thing that comes to mind, again, depending on the degree of the unfairness that you perceive from the agreement, getting the information that you're supposed to, including the background information, support obligations, length of marriage, children, abusive relationship, etc. When you get all these factors in, then what comes to mind is these red flags that may cause you to suspect the scenario there, suspect the idea of why is it that person is actually willing or instructing you, hey, here's an agreement that I have here. It was drawn. I'm okay with it. This is what I want. Please help me complete this. I wanna sign it in front of you, right? And then you ask yourself, well, somebody did that for you. You may have been coerced. You may have been under influence that is maybe unfair. So these are the flags that comes up, and that you have to ask yourself the questions and maybe satisfy yourself better as to whether or not you want to enter that kind of a scenario. So that's the one thing that I think every lawyer has to be aware of, depending again on the degree of the unfairness that you see, based on whatever is being presented to you as the final draft agreement that they don't want to negotiate any further. So that's one of the things. That's one of the topics that you have to really be careful about.
Steph, what would you do? What's your take on this?
You know, as a new call, I don't want to ruin my reputation from day dot. You know, it's very, very, a very delicate balance between ensuring you are supporting your client's goals and interests while also protecting them. I lean more towards the Epstein approach. You know, you want to make sure that your name is attached to something that you're proud of, that you find is just and fair. But then again, going back to what Golan mentioned, there's sort of a degree of what is unfair. Is it, very low scale? Is it massive? So just always something to be mindful of when going through agreements with your client, understanding what your client's objectives are, and just always turning back to that.
Great stuff. Abby, thoughts?
Yes. First of all, I wouldn't put my name to any such agreement, and I just wouldn't do it. It just kind of doesn't matter, the fees. I echo Stephanie's point on that one. I wouldn't put my name to it, and I wouldn't put my name to it for a couple of reasons. Number one, I know that Golan mentioned the degree of unfairness, but when I look at that topic in itself, I'm thinking what the court would deem to be unfair. So that means it's unfair. And having participated in undoing some of those agreements in my career successfully, I know what the names of the lawyers that have their name to it. I know how the names have been bantered around in court. I don't want that for myself. And when it's deemed unfair, you are likely to get it overturned. And then not only is your reputation ruined, or not ruined, but kind of reputation kind of sold somewhat, your name sold somewhat, then your client no longer has confidence in you, notwithstanding they forget these things. Like they said, I don't care, I want to sign it. And then that becomes an issue. And this particular one of the ones that I've been involved in that comes to mind is where they both had lawyers, but it was clear that the equalization payment made to the lady I later represented was based on what the husband could afford, and those were in court materials at the end of the day. So you do not want your name attached to something that could call your reputation into question, because the very next day, or lo and behold, the very next afternoon, you might be standing in front of the judge that has just heard the matter about the deal that you've put your name to. So yes, be careful. Do it if you feel confident, but for me, I would not do it.
Yeah, there's a lot to unpack there. I've set these agreements aside and cross-examined the counsel who signed off on it. He had to notify LawPro. He had his own representative. It was a completely uncomfortable afternoon for him testifying. He testified longer about the agreement than he did spending time with the client. He spent I think that he spent 15 minutes with the client. He was in the witness box for an hour and a half. And it was just a terrible, terrible experience for him to go through. The agreement was finally set aside. I guess, the analysis, is it objectively or subjectively unfair, right? We can apply the legal framework and know is it within the goalposts.
That's right.
But for a while, I was seeing these agreements where clients, usually the husband, would pay a premium, 25% or so. Could have been infidelity or whatever occurred. They wanted the thing done. They wanted to move on with their new girlfriend. They didn't want to litigate. And they willingly paid a big bump just to settle the case. So that's something you got to respect, those instructions at some point. You can't just walk away from every client who you disagree with. So I guess there's certainly a dichotomy there. Kind of leads us into our next subject, which is losing objectivity, mixing business with pleasure. We all Law Society has reported on some lawyers who've slept with their clients. And really, I don't know how you can be objective when you're in a relationship with your client. It's frowned upon if you're acting for friends or family members, let alone somebody who's going through the divorce as well. So that's certainly, those decisions are reported. You can take a look at those, but it's certainly an easy way to ruin your reputation and your career. I see a lot of clients, a lot of lawyers who emote their clients' behavior and take it to court with them. And they believe their clients' statements, no matter what they are, and they actually get upset, like their clients have been getting upset. And I often say to them, you don't need to emote your client's behavior. You're supposed to be neutral and objective. Don't get angry at this case, right? You're losing your objectivity. And then representing family and friends, bad idea. Not only are you probably not going to get paid for it, or you're going to do it at a reduced amount, but again, you're probably not going to be objective. If you're representing a parent or a sister or a brother in a divorce proceeding, you may not be giving them the advice that they need to hear. You may not be giving them the bad news that lawyers should give their clients if their case is going badly. So that's what I'm seeing when counsel lose their objectivity. But Golan, what have you seen?
Well, one of the things on family and friends, you can also look at what the advice to lawyers not to represent themselves. It starts from that same emotional stance that you may lose that objectivity, and you would rather have an outside lawyer take care of your matter, even if you're doing a family law and that's all you do, or criminal law and that's all you do, and all of a sudden you are embroiled into a similar situation and you think you know everything. It may be better to step aside and let the outside counsel to deal with the matter. So definitely the losing of objectivity can come in different forms, whether it's the relationship with your clients, whether it's the clients that are not related, clients that are related, whether it's a family, friends, and definitely something to watch for and try to stay away from. That's the bottom line. You have to stay away from that.
Abby?
I totally agree with Golan. You have, stay away. You cannot be as vigilant as you would normally be. You're not able to assess the matter or the issues as you would normally be able to normally. And, the idea of having a relationship with a client is just not even part of what we should do in our rules of professionalism, and that there's a reason for that. Because you have no objectivity at all, like really, like none, is non-existent. So you don't have the capacity to do your job as well as you should be doing it. So you should not be doing that job. You can't be impartial. You can't see the fairness in it. And quite frankly, not because you don't want to, it's just because you can't, because of that relationship. And the same goes for friends. We should try and stay away from acting for friends and family as much as possible, because who's ever had a sister or brother get divorced? Even when you're not involved, they want you on their side. They want you to say their bad behavior is okay. And you can't really do that successfully if you are a member of the family and representing them in their family matter. Best to stay away, refer them out, and assist them emotionally in that way as a support system, rather than be their lawyer. It never ends well. You may lose your family in the end and they still not pay you, especially if the matter doesn't favor them. So that's what I would say to that. Stay away.
And depending on the relationship, you may even get called as a witness.
Yeah.
Then you're going to have to be disqualified as counsel at that point.
It
almost reminds me, I'm dating myself, of that movie War of the Roses, where the wife comes into Danny DeVito's office and tries to seduce him. And what a scene that was.
Yeah.
Steph, any thoughts on this before we move on?
Don't hate me, Russ, but I have no idea what movie you're talking about.
You didn't even know what Top Gun was when we started the firm.
Well, I knew what it was. I just
It
hadn't
took
seen
us
it
3
yet.
years to see Top Gun.
That's the
I
young
knew it. I
generation.
didn't watch it. No, my articling principal warned me of the same sort of thing before I was called. And sure enough, I'm not sure if the three of you experienced that, but as soon as friends, family members of friends, discover that you've been called, that you're officially a lawyer, I had people reach out and, what type of law are you practicing? Can I get that family and friends discount? And it's just one of those things that um, your friends or your family members might not understand those rules of professionalism and those sort of duties that lawyers are obliged to follow. So it can be a maybe uncomfortable position or conversation to have, but one that needs to be had nonetheless.
Yeah. Again, lots of great questions coming in from the audience. Thank you. We're also going to have a poll for you in a few moments. One question that came in, if you are representing a husband and wife jointly in a real estate closing, then can you represent the wife in family matters? That's interesting. Usually, sometimes the divorce lawyers would do the real estate deal, but I would always get permission from both parties and the other counsel to do so, and I would give permission. It's more convenient. But what if you did the real estate deal first? What do you guys think of that? Golan, can you then represent one of the
Yeah,
parties?
that's actually I'm thinking as the question comes in, and I'm like, I think the safest way would be to get a waiver from the other party in any event. And again, it depends on what went on during a transaction like that. Is that something that discloses sensitive information that may be used later on against the other party? So I think the cleanest way would be not to do it. The safest way, if you decide to do take it, I would say a waiver definitely is needed from the other side, consenting to your representing the other side in the matter. That's kind of what comes to my mind right away.
Maybe the issues involved too, right? Maybe a joint application for divorce that's just filing paperwork as opposed to something more substantive. Abby,
Right.
thoughts on this question?
I think I agree with Golan. I wouldn't as you were asking the question and as Golan was answering, I'm reminded of a matter that I was involved in. And so that I don't want to be like a Debbie Downer on all my questions and answers here. I would say in this one, perhaps it depends. Okay, but you must get consent. And the reason I say that is because I had a situation where this law firm had been representing the parties in real estate deals for many years, buy and sell, buy and sell, buy and sell. So they had a lot of information about both parties. And then when it came down to separation, they started acting for one of the parties. And my client's complaint, rightly so, is that they have so much information about me that they're holding in their back in the day where everything was in paper form that they have. And, are they using some of that information against him in terms of when they buy and sell, where the equity goes, which account the equity is, how the money is being dispersed for their constant real estate transactions that they were doing at the time? In that situation, it would have made sense for the law firm not to have acted and just stay well clean. If anybody needs any disclosure as it relates to the real estate transactions over the past years, just provide it and step away. But I think deciding to act from one party created an unnecessary wrinkle in the whole family matter. And the other thing that happened in that matter was they did not actually obtain my client's consent as to whether or not they could act for their ultimate client. So it became very messy. And, as we all know, family matters are not exactly neat and tidy at the best of times. Why would you want to add that extra layer? But if it's just a regular family, we bought and sold one property, probably lawyer never even met them until signing, and things like that, maybe one would consider it, but making sure that both parties do sign a consent that they can act for one or the other party.
Yeah, great tip. Thank you for that, Abby. All right, Steph, 24-hour rule. What do we need to be thinking about here? Good
Yeah,
practice.
absolutely. I found that clients have a tone or an expectation of tone that they want their lawyers to get across in correspondence. And as counsel, it's our job to have those transparent conversations with our clients as to, what are the other alternatives? Can we look to approach the matter, the correspondence in a different way? What's the true message that you want to get across? And does responding in an adversarial tone hurt or hinder the possibility of getting, what the client wants to accomplish? At the end of the day, the lawyers will walk away from the file, but the parties might have to still continue to deal with one another, especially when there are children involved. So when I find adversarial letters come in, or my client wants to send one out, to have those conversations with your client and to remind them, if their goal is to reach an agreement or resolve an issue, but on the same sort of note, they want to pick apart the other party's actions, or they want to come to the table with like thick armor. Just reminding them we have to think about how that might impact the temperature of a file. How will the other side respond to that? Because when the other lawyer, or if they're a self-represented party, when they receive that, harsh or, aggressive correspondence, and that temperature just keeps rising, is that really going to help your client achieve their goal? So I find the 24-hour rule to be such, a great rule to utilize, because it's very, very easy to get upset and defensive when receiving a letter that's combative or includes claims that are contrary to your client's perception. And it can be increasingly difficult when you have opposing counsel who's, maybe just acting as a mouthpiece or, conveying whatever it is their client wants them to say. So as lawyers, we have to remember those rules of professional conduct, and it is our role to be courteous and to be civil, and, not embarrass the profession, not use language that, makes you look, evil. So taking a moment to step away, work on another file, brainstorm with other associates or mentors, and then come back to that correspondence with a fresh perspective can often alleviate that urge or the natural reflex to respond defensively, or with an equally combative tone. I also find that stepping away and using that 24-hour rule, it allows my subconscious to work in the background. So, I can gain new ideas, new perspectives, strategies on how to respond. And those other alternative approaches, you can discuss those with your client, and really ensure that you're drafting a response that's going to be productive to their goals, and what they truly want to receive. One other thing that I've sort of added to this 24-hour rule, especially when receiving very nasty letters or correspondence from opposing parties, or sometimes opposing counsel, is to be a buffer for my client. So before providing the letter to my client, I'll call them up, let them know that a letter's come in, go through with it, go through the letter with them over the phone, reminding them to see past the tone and focus on the substantial points, so that we can really narrow down what are the issues, get rid of all the fluff, get rid of all the anger, so it softens that kind of jolt reaction from my clients. I find that's really beneficial for, potentially getting a file on track and ensuring that temperatures continue to lower instead of rise.
And with email, it's so easy to send, just hit that send button, right?
Absolutely.
Every
So
time I
fast.
wait 24 hours or I ask my clerk to look at it, the next day I always change the letter, something in the letter. And sometimes I'll get a letter that's particularly nasty. I'll phone the other lawyer up and say, what's going on? And they'll say, yeah, I had to write it for my client. It's not for you, right? How to placate the client because that's the letter they were demanding. And you could usually tell when the letter's written for the lawyer's own client, not for you to respond in any meaningful manner. But Abby, what do you think of this 24-hour rule? Good practice?
Absolutely. And I think I agree with you. As you may recall back in the day, if I was asked by a client to send us such a letter, even after
you would phone me and say, this is coming over.
Yeah, exactly. Do you remember? I would phone and say, hey, Russ, letters coming, just so you know.
I'm instructed to
I'm
send
instructed
you a
to
letter.
do this. So
Yeah.
by the time the letter gets onto Russell's desk, he's not jumping up and down. That's how we used to do it back in the day in our community. But you know. So I would do that. And now still, I probably would still do that whether I know the lawyer or not. And what I find is that the lawyers would appreciate that call. Because you're not coming to them in an adversarial manner. Now, I guess as you progress and advance in years and in practice, you learn and you do better. You know, being a mediator, being a collaborative trained lawyer, you know, I don't rise to those occasions as I used to when I was younger or only litigating. But we're all human. So if I get such a letter and I'm like maybe on a 3 p.m. on a Friday afternoon or something like that, I would do what Russell said he does. I would dictate it so that I get it out of my system. I wouldn't send it, but I'll dictate it, because otherwise I'll be thinking about it all the time. But once I put it down, then I can walk away from it. Then come Monday morning or Sunday evening or whatever, and I go back to it, I'm like, yeah, I don't really feel like that anymore. Then you start over. But so that it doesn't eat me up over weekend or me over the weekend, or I get annoyed, or I'm like, what is it thinking? Whatever. I would just respond, put it down and get it out of my system. And then wait the 24 hours or whatever to then deal with it. And if I'm going to send it to my client, I will preface that by a phone call to my client, to be fair, so that they don't receive this and, you know, the ex in the background is getting some sort of reaction, or the kids are getting a backlash or whatever. So I'll phone them and say, this is happening. You know, I have spoken to the other lawyer. Well, this is how we can deal with it. So I diffuse it before my client gets that letter. But I will share that letter, because I share anything that comes in, I share it with my client, because it's your matter at the end of the day. So those are my thoughts, Russell.
With AI, you can just cut and paste it, say, make this more professional, empathetic, and in compliance with the rules of professional conduct.
Well, there you go.
Better for you, but
there you go.
It's also,
Even
though there's 56,000 lawyers in Ontario, it's an incredibly small community. So this is one file, one letter. You're likely going to be working with this lawyer for the next 25 years. You know, your letters are going to set the tone of that relationship. But Golan, what do you think?
Yeah, I was just thinking about that, because I think Stephanie was talking about clients being that the heating between the atmosphere is between the clients, and I'm thinking, think about those of us with short fuse and just wanting to stab, you know, in cold blood the other lawyer just because they don't like his looks, or they don't like you know, his glasses or whatnot. So the idea is, firstly, the rules of civil of professional ethics requires us to be civil. That's out of the question. It's not it's a given. So the idea of the letter, and
lawyers could be civil and sarcastic and mean spirited all at the same time, right?
Right. That's the beauty of advocacy, right? You can say things and you can read between the lines. But the thing is that, and so two points here. The first one is the code of, it's for my client. See copy client tells you everything. So when you have a letter, a nasty letter, that at the bottom of it you see copy client, I'm like, I don't ever write on my letter copy client. I don't need my other side to know what I'm communicating with my client and whatnot. You can assume that it's been approved or not. It's your choice. But I see that was an old-fashioned way of putting of showing that who am I copying, who's communicating on this email. So that's the first kind of clue that you get, apart from the fact that what you can do is, firstly, if it's personal attack, which is different than, you know, showing a disregard to your clients, a respect or anything of that sort. That's two different topics, right? Because a personal attack, you feel the need to answer right away. This is where your blood may boil, right? That's where the 24-hour rule is absolutely necessary for you to calm down, cool off, and then see again clearly whether you want to respond it, whether you want to mild the tone of your response, and whether the law society needs to be informed because it was so outrageous. So that's you have various options that become available. I would rather you talk to other counsel before you go to the law society, because it's a matter that has to be resolved, to kind of bring to the attention of the other side that it's not appreciated and it's not the relationship you want to have with any lawyer, and this is just one more file. So that's one of the things. And then when a lawyer starts writing back something, it may cross the line to anything from being uncivil to sharp practice to anything of that sort. Once you start making claims and allegations against your client or against the other lawyer, this is where things get muddy. And this is where things that you want to avoid, in terms of you want to keep your composure, your professionalism, and stick to the merits of the case. One of the things that I wanna take another few seconds, if I may. Abby, I think Ross, even you and I had a discussion over what is it that the clients must be receiving from the other side's communication. My take on it was, I can rephrase whatever information I'm getting. So if I know that a letter is coming in to intimidate my client and cause him to change his position from one end to another just because he's learning of this aggressive behavior of the other side, I don't see it as I need to send him exactly that with the tone and everything else that's been said in the letter, but rather I will make the reporting letter to my client. Here is the position of the other side, 1, 2, 3, 4, and take the nastiness out of that. You really take the edge out of that correspondence that came to you. I don't see that as an incompliance with any rules that requires my client to be informed with anything that happens in his matter, as long as I provide him with all the information. But I don't need to, load. Is already emotionally charged. Why do I stress him more with just because another lawyer wishes to take control over his mental state and cause him to change his position, etc. So that's the way that I deal with such extreme situations, where I don't think that a client needs to hear it or to read it, verbatim, as opposed to rephrase the topics and the letters and just convey the information in the way that you feel is the right way to do. That's my comment on that one.
I want to be mindful over time. Let's get into when trouble comes, and it comes. Golan, I got you talking about this one. This seems to be your specialty tonight.
But you make it sound like I'm getting in trouble all the time.
No, not at all.
No, I'm just thinking, listen, if you've been around long enough and you appeared in court and you dealt with other lawyers and you dealt with clients, those who don't make mistakes. Those who do stuff and always busy, there's going to be some rubbing against another colleagues that may not be pleasant. One of the things that you can experience is complaints from firstly, you can experience that right at court with impression from judges, the way that they may be speaking with you, the attitude. And let's not forget, everybody's human, like we mentioned before, and some of us may get up on the wrong side of the bed. And one of the things to avoid, and I think that takes away from the nastiness or the bad attitude, is if you come prepared to court, that takes away that edge of there's no reason to be mad at you when you are really know the facts and and prepared. So you can stick to the merits, you can stick to the arguments that make sense. You don't have to fall into a discussion or what we call a pissing contest with a judge. It's never going to end up well. It's just going to I don't think it's going to serve your client well. That's the bottom line. It's not going to be there. And we spoke about reputation before. Well, this is your reputation. Your reputation is in court, and judges make a impression of you and may discuss it later on over lunch with other judges. And everybody likes to gossip. I think judges are just the same as everybody else. The extreme, and I've seen that before, is judges that made a referral to the law society to complain about about another lawyer. That's another situation that may arise. So you may now be dealing with the law society with a complaint because it was referred by a judge. Obviously, it's giving the attention that a judge would expect it to receive. So you really have to. It doesn't mean that you have to capitulate on your arguments. It doesn't mean that you do not need to be zealous or make the strongest argument you can for your client. But it means that you do not need to fall into a unnecessary argumentative discussions, whether somebody's disapproving of something you did or anything like that. You can always stick to your points, be respectful, get your point across, and everything is on the record. So when the time comes, if it ever needs to be reviewed or appealed or anything that you need to refer to, it's there black on white. That's my
That's a
suggestion.
great point. I would preserve the record. So judges have bad days too. And I've been taken over the coals a number of times. It's important if a judge is raising his or her voice, that you indicate that on the record, because if they order a transcript, they may not. If they get the audio, they'll hear it. If they order the transcript, that won't come across. If they're not allowing you to make proper submissions when it's your turn, you need to put that on the record as well. Basically, you're preserving the record in case the decision needs to be appealed. So not only what you're experiencing in terms of submissions, your client's right to be heard, the judge's demeanor and decorum, you should repeat that back and mirror the judge. Just say, I hear that you're raising your voice over this particular issue, and the record will reflect that. And if necessary, the audio version of the transcript can be ordered as well. So I think that goes just to preserve the record. Poll is, have you ever faced a situation where you had to respond to a complaint from the Law Society of Ontario? And let's see what our audience poll results are for this one. It'll be interesting. Yes, 38%. No, 62%. Interesting divide. Well, Law Society complaints. What do we need to know, Steph? I hope you're not an expert on it, but certainly talk about this, Emily.
Not an expert, no, but something that you actually, speak about and encourage all of our associates to do is to normalize Law Society complaints. Especially working in family law, we're dealing with highly sensitive matters, people's lives, their children. And unfortunately, sometimes the outcome is not what the client had hoped for. And their instinct is to blame someone, to blame their lawyer, even if their lawyer had no control over it. So if you happen to receive a complaint, whether it be directly from the client or the Law Society, some things to remember is to always deal with it right away. You don't want to have to ask for an extension, or you don't want to push it to the side because it's scary to face. I'm sure it's a human reaction to want to avoid something, especially when it's daunting or terrifying, but you can actually get yourself in more trouble by not responding. And when you are preparing your response to a complaint, it's always best to be honest, respectful, and extremely detailed. Review your file, your notes, emphasize your legal strategy, and from day one of having a file, keep record of everything, of your discussions with the client, any instructions received, whether they be over the phone or in writing. If you had a telephone call with a client and they provided instructions over the phone, always follow up with an email outlining what you discussed. Ask them to confirm their instructions again in writing. Just making sure that you're doing your due diligence throughout the entirety of a file so that if something were to come up down the line, you have everything readily available. Another thing to remember, and it kind of goes back to, this duty to be civil and courteous, especially when emailing your clients or self-represented parties, other side, whoever it may be, is to be polite and respectful in your correspondence. If a complaint comes in, the Law Society will see your emails. They'll see your correspondence. So you can take an informative position. You can take a strong position while still being respectful. And sometimes law society complaints don't come from your client, but from the other side. They may be acting out of spite. So always being respectful in your communication and how you carry yourself is important, because at the end of the day, you are representing the profession. And the last sort of tip or maybe recommendation I would say when responding to a law society complaint is to lean on your colleagues, your mentors, get an objective perspective on how your response is perceived by an outside party. The person handling and making the decision about your complaint, they're not going to have the knowledge or the details of the file. They're not going to know it as in depth as you do. So obtaining that objective perspective, having a colleague proofread your response can ensure that you're conveying a compelling response and you're being, as thorough as possible and leaving no holes open. So those are sort of my tips.
Great tips. When I got my first complaint 3-4 years out, I thought the world was going to end, right? Oh my God, what's happened? I went to law school, now I got this complaint. Called up my articling principal. He goes, listen, if you're not getting 2-3 complaints a year, you're not busy enough. It's just the nature of doing family law. Eventually, you're holding tail this tiger, going to turn around and bite you, or the other lawyer eventually. So 30 seconds or less. Abby, reporting LawPro claims. What do we need to keep in mind?
We need to keep in mind that we have to, if there is a potential, I'm going to echo what Stephanie said right there. Speak to a senior colleague or a senior lawyer and just check in whether this is something you should self-report. Because if there's a tendency to not self-report and it becomes a bigger deal, the consequences are very dire. First of all, you could lose your insurance coverage and where you can't practice anymore, because without it, you can't practice as a lawyer, and we all cherish our certificates and the ability to practice. So self-report if necessary. Check in with a mentor, check in with a senior colleague and say, this is what I'm experiencing, what should I do? And self-report, do it immediately, because when you self-report, you have to tell LawPro, when did you become aware and when did you report? So that gap in the timelines will become important as to where you're trying to hide, and you only reported when things have got out of hand. You could get into a disciplinary action with the law society as well, and you don't want that. If there's financial issues there, you could get a lot of you could get into a financial liability, especially when your insurance now has become in question, or you lose your coverage. So there's a financial liability that you could expose yourself to. And also, your reputation. We've talked about that all along throughout this. Your reputation is something that, we all cherish. We all want to guard with everything that we have. So, and that becomes something nobody wants to be reported in the newspaper about how they've acted or conducted their file and failed to report when they noticed an error. Do I have more time to continue?
No, that was really good. But thank you. It's easy to report. They're on your side. If you're at all have any doubts, report it. And if there's an error, they'll mitigate the damage and hire a lawyer for you. So it's a good thing to report it. So what I'm trying to get away. Hire experienced counsel when trouble or law society knocks on your door. That was a great summary, by the way, Abby. So, you want somebody with experience who's dispassionate, who knows the workings of the law society. You want to be able to cooperate with any requests the law society makes, but still protect your rights and your reputation, your career. So a lawyer can say, yes, I'm going to cooperate with, this person's going to cooperate with your request, but with the following caveats. And there may be disclosure issues, privacy issues, a whole bunch of issues that could come into play. Some great counsel that do work defending lawyers at Law Society tribunals: William Trudell, Gavin McKenzie, Peter Griffin, that last nurse Saint, Brian Greenspan. Just ask around. There's great lawyers there to assist if you ever need help dealing with any trouble that knocks on your door, and you think certainly to have that objective counsel is important. Final topic: role of mentors and colleagues as you staff
Absolutely. I would just say that establishing a network of mentors and colleagues who you can trust, who you can go to for advice is super helpful, not only as a new call, but for lawyers at any stage of their career. I quickly discovered, we're always going to be learning. You're never going to know everything. You might not experience a certain legal issue until years into your career. You might have a new client personality that you find challenging to navigate. So having other lawyers you can turn to is super important, even if it's just for your personal sanity. It doesn't mean sole practitioners don't have that option as well. You can join groups, practice groups, social groups, network as much as possible. If you are in a firm, lean on your colleagues, establish those relationships. And don't count opposing counsel out. You might have an opposing counsel on the other side. And, once you're done with dealing with that matter, they can become a great resource, a great professional relationship in the future. So again, tying back to always being courteous and carrying yourself with grace, it's really going to help you expand your network and make those connections that will help propel your career.
Great stuff. Golan, Abby, any final thoughts or tips?
My
I
last
thought,
one.
I thought,
Oh, sorry. Go
I'm
on.
sorry, Abby.
Abby, go
My,
ahead.
my quick 2 cents is just for generally speaking, for lawyer to draw encouragement from the last poll, that 40% of them were somehow reported to the Law Society. You can imagine that only a fraction of it, if anything, is actually true in terms of malpractice of any kind. But 40%, that tells you if statistic plays a role in this group of 150 or 200 people that are watching us and participating, it tells you a lot about the frivolous complaints that coming through the Law Society, and much of it has to do with how do I get leverage to get my money because I did not get him the result that he wanted, or I don't like this lawyer on the other side, and this is what I'm going to do to him because he got his client what she wanted or he wanted, but I ended up with the short end of the stick. So just that's my comment on that topic. Mentorship, always a great thing, and people should always have somebody to go to and get advice on.
So I hear you saying, so Golan, there's solace. We're not alone out there. Everybody else is going through the same stuff. Abby?
Yes, absolutely. We're not alone. On the mentorship is just what I wanted to just make one last comment on. I totally agree wholeheartedly with everything that Stephanie has said about why you ought to have a mentor. I have mentors. I've had them since the day I started practicing in Canada, and you never get too old for it. But apart from the knowledge, apart from the networking opportunities, apart from the professional guidance you get, I find the emotional support very, very useful. We are all going through a lot of stress. So just the idea of having to speak to someone, especially in before, but in the light of COVID, speaking to someone about what you're going through over a cup of tea or something like that makes a lot of difference and helps with our emotional support. It helps you sometimes to build your confidence as well. Someone says to you, you're doing okay, and you're panicking and you're doing okay, boost your confidence. It's not knowledge transfer, but it's just that emotional support that we all lean on each other for. And I think it is a good thing.
Great tips. Thank you, Abby, Golan, Steph. Excellent presentation. And Shannon's back. That means we're going to wrap up day one.
Thank you so much, Stephanie, Abby, and Golan. Really great insights. I feel like a lot of the things that you mentioned too can apply beyond the legal profession too. So thank you so much for sharing. And thanks to all of our speakers today. We had a really great lineup and looking forward to another great day tomorrow. And also want to thank everyone for their generosity and support of the Denise House today. We have moved the dial up with our donations. So thank you so much to everyone who has donated and for everyone who has supported this event.
All right. And certainly thank you to the speakers today. Everybody was just spectacular, including the ones we have on our screen. Thank our audience and everybody watching live on YouTube. Everybody's played full out, answering the polls, sending it in. It's great questions. So I'm looking forward to seeing everybody tomorrow. Have a great night, everybody.
Bye, everyone.